Hello, everybody, and welcome to the Genesis Legal Group Co-Parenting Compass. We are so excited to have you and for our first webinar of the new year. This is going to be a workshop style webinar, and we're super excited to bring to you some questions and have you ask your most compelling questions for us so that we can help you navigate what's really most pressing during your co-parenting journey. So while we're waiting a little bit longer for some of our attendees to show, why don't you grab some coffee or a favorite snack, and we'll be with you momentarily. Thanks so much. Hi, everybody, and welcome back. We sure hope you were able to get something to enjoy this next hour. In addition to myself presenting, I'm Sabrina Shaheen Cronin. I'm here with my lovely colleagues and assistants helping me with this amazing presentation. I have Samantha Sharples to my right and Alicia Sambrone to my left, as well as our attendees in the back who are amazing team members. Kim Cochran is our senior attorney, and Ariana Lava is our legal assistant here at the Genesis Legal Group. Thank you so much for being with us, and we hope to make this really a valuable 1 hour for you, a great workshop to help you navigate some really tough, difficult situations that sometimes co-parents face. So without any further ado, let's get started. And why is co-parenting so important? You know, us here at Genesis, we really focus on co-parenting because at the heart of every family is really our children. And while romantic relationships may end, parenting is truly a lifelong commitment. And while couples may separate and no longer be a part of each other's lives on a daily basis, we are always forever going to be a part of our children's lives, so long as we are living. And so it's super important that our children know that we're there for them and that we really work toward making them our main focus, even during a really tumultuous separation or a divorce, or even if a divorce is going pretty amicably. It's super important to always put the children at the forefront. So for our workshop today, our roadmap is really going through some of our legal foundations for co-parenting, understanding the key principles and some of the common terms that you might or might not be aware of. We are going to also be presenting some various hypothetical situations to help you resolve some of your own disputes that you might have. Some of them are more common than others, and we can give you some practical tips and advice for avoiding or really addressing conflicts so that we can keep conflict to a minimum. We'll help you with some tools and resources so that when you are unsure of which way to navigate, you'll always know that the best foot forward is something that you're taking because you know that you've done the work and you're really looking at all the resources in the best way possible. So how do we build our legal compass? Well, we're building it by looking at all the different components. We have custody and visitation, where some of you may or may not be aware, there are various forms of custody. We have physical custody, which is where we look at when the children primarily lives, versus legal custody, and that is the decision-making process. Who has the right to make decisions for that child or your minor child? Which parent? Do you share sole legal custody? And do you share physical custody? And in many states, physical custody is comprised of parenting time. So sometimes in different states, there's really no such thing as physical custody. It's really more about the parenting time schedule. And we really look at custody in terms of the legal custody. But in any event, when we look at custody in general, we're looking at the schedule. Where are the children? Where are they living primarily? Who has quote unquote primary custody, or is it joint custody? Do both parents have joint decision-making power? And those are the things that we look at in most states across the country. And we also look at child support, and child support is primarily determined on the custody arrangement, the physical custody arrangement, and or the parenting time plan. So depending on how many overnights a child gets with any particular parent is really determinative of the child support. Or rather, the child support is determinative based upon the amount of overnights that child has with any particular parent, in addition to other factors like income and medical and health and all of those other types of insurances that go into that child's life. So we're going to start with our first question regarding child support. We often get so many clients calling us with frustrations about child support. And I don't know if you're similar to some of our clients, but many times they're very confused and they're frustrated because they're paying all this money in child support and they feel that it's not going toward the benefit or the betterment of their child. So I'm going to have Samantha read this question and let's just open the forum up a little bit to discussing some answers.
Thanks, Sabrina. So for our first question today, Scarlett and Ryan exercise equal parenting time with their children on a week on, week off schedule, and they have a decent co-parenting relationship. Scarlett is frustrated because she's been ordered to pay Ryan nearly $5,000 per month in child support for their 3 children, and she's pretty sure Ryan uses the money to go out to dinner, watch movies, pay his bills, and buy new furniture and other things for his house. Scarlett believes that she should only have to pay Ryan if he uses the child support money for the kids and provides the receipts. Do you think Scarlett would win in court if she were to bring forth this information?
Well, do we have any chat participants? And I wanted to also mention that this is a very safe space, that this forum is really created and designed for you to feel free and safe to open up and to discuss some of your pressing concerns. We ask that everybody respect everyone's privacy and that if you don't wish to be visible on screen, that you don't have to be, and that your names are hidden so that you do maintain that anonymity if you so desire. If you wish to be heard or seen, that's absolutely perfectly fine. We're happy to open up discussion, but if you prefer just to ask your questions via chat, please you can raise your hand in the chat or ask your question in the chat, and we have Elisha monitoring that as well. So, but this is a common frustration, and Sam, I know that we have a lot of clients that this happens to.
Mm-hmm.
So unfortunately, for many, what is not understood is that child support goes to help the other parent with the basic needs of that child. And the basic needs are food, clothing, and shelter. Now, even if Ryan is using the money for sometimes his own pleasure, what it's going to be difficult to prove is he really using it for his own pleasure, or is he really using it for food for his children, or to help with utilities, or to help with the mortgage or the rent payment? So Sam, what are your thoughts on that?
I definitely agree with that, Sabrina. And I think a good way to think about this type of scenario, especially when it comes to going out to dinner or paying the bills or buying new furniture. I mean, the three children in this scenario are really going to benefit from getting the bills paid, like the mortgage, utilities, Wi-Fi, things that they might need for school. But also, I mean, new furniture, maybe that furniture was because one of the children needed a new bed, they got older, or there were some, Ryan deserves to have fun with the kids too. Maybe they're going out to movies together. That relationship between the children and Ryan is really important. And it's also, the courts consider that when they put this into the order. And we have to really work on remembering that child support is for the children. And just because the other parent may be getting, a little bit more money, that's money that they can spend on your kids to make your kids, you know, be happy and taken care of.
I know that in many agreements, what is often done is something that deviates a little bit from child support, in that the two parties involved agree to either split extracurricular activities, or if a child is going to a private school, they can split that cost. Or if one parent makes a little more money, they agree to pay the private tuition. If one parent wants the child in a particular sporting or extracurricular activity that the other parent cannot afford, then that's also agreed upon. There are many different ways to help support the child and the other parent in raising that child. But what you have to remember is ultimately, it's really in your child's best interest. So however you agree on the money aspect of your child's rearing, or being, your child being raised, is really something that you need to think about and talk to your lawyer about, and make sure that what you're doing is in the child's best interest. And try not to think of it as money going to the other parent. Try to think of it as money going for the benefit of your child, because that's really ultimately what it is. And even if you have to pay a little bit more when you have the child for other things that the other parent isn't helping, it's for your child's best interest. And so try not to think of the short term or the myopic view, but really think of it in general for the best interest of your child. So we are going to talk about some various common issues that come up during some of the co-parenting and legal, matters that happen, and some of the things that happen during either a co-parenting plan gone awry, or just an agreement that is trying to get decided upon. Sometimes we have an agreement that is already set in stone, that's already agreed upon by the two parties, the two litigants, and it's already done. The court is not in the picture any longer, and the two parties are going about their day-to-day activities, and they're living their lives. And sometimes something comes up where that judgment or that final agreement, that decree, has to be modified. Now, in certain situations, it's extremely difficult to modify a final judgment or order of the court. So we often, in almost every circumstance, we advise our clients that please make sure this is truly what you want, because once you sign on that dotted line, it is very, very difficult to change that final judgment. So we often will instruct our client on that. However, we do have many, many post-judgment matters that we can take on very successfully if there are certain things that happen, such as a move, a relocation, an income change, if there is a significant change of circumstance with respect to the other parent, if maybe the other parent is now involved with another person that is abusive, or that is taking the child and not always doing what's in that child's best interest, if there is some alienation issues. So we often will tell our clients, please keep a journal. Let's make sure we have enough evidence to move forward. But there are definitely remedies for weathering common storms, which often occur post-judgment. And when we talk about relocation, now, many nation, many states in our nation allow for a move within 100 miles. However, if there is joint legal custody, which most oftentimes there is, that means you still have to have the approval of the other party to move outside of the school district. If you're changing schools and the other party does not agree, well, then you're gonna unfortunately have to go back to court to try to get the court's approval for you to move, even if it is within that 100-mile radius. So those are various challenges that we like to try to make sure we address and look at every contingency before we file or sign on that dotted line for the initial judgment. So while your lawyer might not be able to predict every contingency prior to that judgment being entered, it's super important that you become very clear on how you see the next 5 to 10 years of your life and your child's life, so that you can try to predict a contingency that might come up later on to prevent you from having to go back to court and hiring another lawyer or the same lawyer to re-litigate issues that should have really been addressed earlier on. So we have another hypothetical question that will definitely address some common challenges that we see with some of our clients. And we have come up with this scenario that we hope you can just read along with and think of some answers for us. And you will also talk about some answers as well. But Jennifer and Ben are recently divorced, and they have 2 children, ages 15 and 9. Their 15-year-old daughter has recently become extremely aggressive and standoffish, and Jennifer is really concerned about her own safety and well-being. Jennifer did her very best to talk with Ben, her ex-husband now, about what she noticed with their daughter. But Ben has refused to recognize the issue, often telling her that there's nothing to worry about. And she's often, we always hear it, well, my child is doing great when she's with me. It's just you, right? We hear that a lot. So, but it's now been several months since Jennifer and Ben had this discussion, and their daughter's behavior is really getting out of control, more and more increasingly out of control. She's skipping school, she's becoming physically aggressive, and she's definitely refusing to communicate with her mom, Jennifer. Jennifer strongly believes that her daughter should see a therapist, but Ben is refusing. So again, with legal custody situations, both parents have to agree when it comes to the medical and health and well-being and educational situations of their child. So in this situation, because Jennifer is not getting any cooperation from Ben, she met with her attorney. So they decided, Jennifer and her attorney decided to move forward with filing a motion. As their hearing date approaches, Ben has suddenly had a change of heart, and he's becoming more open-minded about therapy because he's also now noticing that their daughter has issues. So what is the best way for Jennifer to discuss her concerns with Ben? Sam, do you have any ideas?
So situations like this, Sabrina, as you said, we hear them pretty often. And honestly, the best way to start having this conversation, in my opinion, is to make sure that the conversation focuses on what their daughter is experiencing and what each of the parent is noticing when they're in their care, not, and we do hear it, well, when she's with me, she's fine. We don't want to cast blame. We don't want to say, Ben, you caused this, or Jennifer, you caused this. We need to make sure that the conversation stays focused on the child and is not necessarily emotionally charged, more so a concerned parent trying to make sure that the child's okay.
Absolutely. And if anyone participating today would like to talk or share their thoughts, we're very happy to hear that. But it is always best to try to discuss things, just really amicably and keeping in mind the best interest of the child without blaming or shaming or guilting anyone or any other parent into something, or causing, that other parent to feel like it's their fault that their child is, acting out. Many times children just act out, and sometimes it's because of the divorce. Sometimes it's because of other factors. Children have a lot of pressure on them these days, and it's super important for both parents to be aligned when it comes to their well-being. So if if Jennifer and Ben can come to an agreement, what do you think that they should do? And what kinds of questions should Jennifer be prepared to talk about with her attorney if Ben does have a change of heart? Sam, would you like to talk about that?
So I definitely think that it's important in these situations. Of course, we encourage everybody, try to come to an agreement on your own and do what you can without court involvement. But in the event that there is a little bit of concern about maybe which therapist, we agree therapy, but which therapist, maybe Jennifer could go to her attorney and see if her attorney knows any resources. Attorneys generally are well versed in several resources to help with co-parenting, any concerns with children, and if anything needs to be addressed further. And I think Jennifer should also be prepared to ask her attorney what they need to do legally. Do they need to file something with the court? Does there need to be a new order? Or can they just do it alone? I mean, it's really going to depend on the circumstances.
So if they already filed the motion and if they're going to court, but then Ben decides that, no, I really agree with Jennifer, then my recommendation, if you find yourself in this situation, would be to have your lawyer prepare an agreement. In our state, we call it a stipulation and order. So both sides can agree. You don't have to go to court for the motion, but at least there's something in writing binding the two parties to cooperate together in getting their daughter the help that she needs to make sure that she's taken care of. And so that they don't have to go back to court if all of a sudden Ben, changes his mind. So that way, that prevents the attorney from having to refile the motion. And at least there's something in writing, something with the court, because remember, in every state, the courts speak through its orders. So unless it's an order of the court really has no binding power over that issue. So it's super important that if you really truly want to prevent it from happening again, you make sure that it's in writing and that it's a signed order from the court.
That's actually really perfect, Sabrina. We did get a question in the chat. And so Sarah asked if it would still be best to continue with legal action so that the father in this scenario couldn't go back and change his mind later, because something is documented, right? And so I think that, that touches on that very perfectly. Do you have anything else to add for Sarah?
Well, Sarah, thank you for asking that. But yes, that is a very poignant point, a very poignant question. That is why it is super important, even if they agree, if the motion was filed, then you should definitely get that stipulation in order so that the court knows that, okay, they resolved it amicably, which also looks good and very favorable to the court or the front of the court in any situation, that the two parties are working together. Because if it were ever to come up again, you have that document, that piece of evidence to show, look, they tried resolving this amicably and it didn't work for whatever reason, and let's go back and address it. And Alicia's asking the question was going to that same point that, yes, it's super important to have it in writing. And if the motion was never filed, it's still important to get something in writing. Thank you for that, Alicia.
And so the last one.
So should Jennifer talk with Ben and try to settle, or do you think they should wait to hear what the court has to say? Well, again, that really went to Sarah's question and what we were just discussing, in that a settlement is always better when the two parties agree and come together. They're the ones that know their child the best. A court, although the courts usually have the best interest of the child in mind, they don't know your situation like you do. They're really truly strangers coming in and trying to dictate how you should raise your child. It's always best to have the two people involved doing what they think is in the best interest of their child, rather than, the judge or the friend of the court, referee or counselor or mediator. So our opinion here at Genesis Legal Group is for the parents to always try to get along, to try to resolve their differences, and always have the best interest of their child at mind and in heart. So that leads us to this next slide, staying child focused. When we look at the legal standards, courts consider several factors like emotional stability, consistent routines, the ability of the parents to cooperate. That is all looked at when determining custody and parenting time. So in many states, there are the best interest factors. Which parent is better suited in different matters and different ways of being a parent to that child. And you should always, always talk to your lawyer in your state to make sure that you are addressing all of the issues that you might have. If you have concerns that the other parent might be abusive or might not be meeting the needs, the basic needs of your child, and that's very important. And always keep a journal, always make sure you gather the evidence necessary, because child custody litigation matters, or any type of matter involving child custody, is a very strenuous, very straining and emotionally draining process. And so we always make sure that our clients are well prepared before going to court, because it's one thing to assert something and it's another thing to prove it. And so we always have to prove our position. And it's sometimes frustrating for the parent to feel like they have to prove it, but that's just how the courts work. And that's why we like to try to get along with the other side, to try to get what's in the best interest of that child, to try to come to that agreement. But in extreme situations, oftentimes that's not possible. So when we try to align with the other side, we want to frame discussions around the child's needs rather than allowing personal vendettas or grievances or frustrations or conflicts. We try to take the emotion out of it, because in any situation, parents that are separating or divorcing just aren't getting along. So it is very hard to set aside the emotion for the betterment of the child, but it is very necessary in order to stay child focused.
So Sabrina, with that being said, we do have another question in the chat. And Rami is wondering, in regards to the best strategy to communicate effectively, and when we talk about framing these discussions around the child's needs, if we have a co-parent who is especially difficult, would you say that this is the best strategy, or do you have a better recommendation?
Dealing with a difficult co-parent is hard, because you're not together for a reason with that co-parent, right? We can agree to disagree, right, with the other co-parent, and that's truly what we have to keep in mind. Just agree to disagree. If the other co-parent is more toxic or is the one who is inflaming the situation, do your best to always try to take a breath, not react, put things in writing in a professional manner, not in a hostile or vindictive way. Try to text or email. Keep your messages brief, without any type of accusing tone or any type of lashing out. It's always best not to react. You can respond once you gather your thoughts, once you take a breath and you realize, okay, this is not going to get me anywhere to, be a jerk back to this person. But just staying child focused, always moving, and your actions should always be motivated by what's in the child's best interest. When you keep that in mind, that will help to really guide your steps moving forward. If reacting gets you nowhere, obviously, then don't react that time. And if you did it, okay, don't beat yourself up. Just try to, move forward in a positive direction. Don't focus on the past. Focus on how you can change now to do what's best for your child. And again, I recommend either a text message or an email, communicating that way, using apps that your lawyer has recommended, so that if and when the time comes, your lawyer or the court can intervene and look at those communications. That really keeps both parties in check to make sure that they are staying really child focused and not being cruel or vindictive. No swearing. Just whenever you communicate with the other parent, just try to remember that it could potentially be viewed by a judge, and that will help keep your, everything in check and make sure you stay child focused. And this takes us to our next slide of bridging the gap. It is super, super important, as we were discussing, to avoid any type of miscommunication. Keep your emotions in check. Always have very clear texts or emails. Don't have angry voicemails. I know it is so easy to get triggered, especially in the early days. When the emotions are still flaring, if it's early on in the co-parenting journey, you just got separated or divorced and you're just now dealing with the back and forth. You're still trying to settle into the whole new just picture, right? You're navigating the new land, so to speak. It is difficult, right? We're not robots. We're emotional beings. That's what makes us human. But again, really try your best to act in a manner that is suitable for a court to view, for a friend of the court to view, for a counselor to view, and always try to act in the best interest of your child. Do what you think your child would be proud of. You know, it's your children love both of you, and it's not fair to put them in the middle. Don't get them involved. Don't discuss your matter with them. Don't disparage the other parent to them, because they're one half of that other parent. And over time, that really wears on their self-esteem and their self-confidence. And we don't want to do that. You know, they have enough issues and enough problems as it is. So if it's necessary, use the tools that we mentioned, the Family Wizard, App Close, or either other court monitor tools. We don't support, we're not sponsors of any of these. We're just offering them as some advice, some guidance. But really try not to be emotionally charged. Just be that mature person. And if you have to work on yourself, that's fine. Do it in order to know how to deal with someone who's a little more toxic. It's best for you to empower yourself, not to react, and just you gather the strength from within. And really, eventually you're gonna have to learn how to walk away really emotionally and just not pay any attention to it. And the less attention you give it, the less focus you give it, the less it will matter in your own life. Because what we focus on grows. And so if you focus on the positive and you focus on your own life now with your child, then that's what will grow. Don't focus on the animosity that is caused by the other parent. Just don't even pay your attention to it. Ignore it as best as you can and move on. So during either a separation, divorce, a custody matter, or even the post-judgment way, if you have an issue post-judgment, like we talked about before, there's certain ways or strategies that you can deal with these things. There's alternative dispute resolution, which is mediation, or other types of collaborative divorce measures, which we'll talk about briefly. So mediation is a way where the two parents can talk and decide what's in their best interest, how they can settle this without too much court intervention. Now, for those people opting for litigation, when one party sues the other party, sometimes that's necessary, especially in high conflict custody battles or when one party refuses to cooperate. Now, in many states, the collaborative divorce process is designed where the two parties will talk with a neutral third party, but if there is any type of dissension or disagreement, they still have to go to litigation. So, and also when you're in litigation, many judges require mediation, which is a different form of a settlement process. It's like a facilitation. So there's a lot of different terms, a lot of different strategies. And it's super important that you speak with your lawyer about what you think is in your best interest so you can navigate the way forward in the best way possible for your particular scenario. Every case is unique. There's no two cases alike. There are no two people alike. So it's very, very important that you speak with your lawyer and you get the best course of action for your particular facts. So in line with the sample that, or the ADR versus traditional litigation scenario, which we were talking about, we have another example. So I'm gonna ask Alicia this time to read it. And Alicia, if you will do.
You got it.
That's a favorite read.
So ADR, just for those of you who may be a little unfamiliar, when we talk about ADR, we're talking about alternative dispute resolution. That's what it stands for. So Joe and Sophie were married for about a year when their son Max was born. Within 2 months of Max's birth, Sophie left the home with Max without telling Joe and refused to disclose, their whereabouts or her plans. So Joe quickly filed a divorce action along with a motion for custody and some parenting time, and he was hoping to be awarded full custody of Max. Not only does he feel that he's a more responsible parent, but he fears for Max's safety based on Sophie's irresponsible lifestyle, her parental alienation, and her documented alcoholism. Joe knows that a son needs his father, and Sophie will do anything she can to keep Joe out of Max's life. Sophie is now threatening to move out of the state, claiming that Joe doesn't have a say in the matter. Joe strongly believes if Sophie has custody, she will not allow Max to participate in hockey, Boy Scouts, or baseball like Joe wants him to. Additionally, Joe is confident that Sophie will do whatever she can to maximize her child support payments each month, including lying to the court and her attorney.
Do you have any concerns with Joe's stance on these issues? And I'm actually gonna ask Kimberly, our senior attorney, who's amazing, to talk about this.
Well, this sounds very familiar to a case I'm working on right now. And it's not good to alienate either parent, of course. The children involved need to be with both parents. Some parents do have issues. If there is documented alcoholism, there are ways to handle these things. Not just taking a child away and not letting the other parent be with that child. There are definitely ways to handle all of these things. So as we've said all along, document what's happening, speak to your attorney about all of these things, and your attorney can help you come up with a game plan on how to get things resolved. But the end result is always to have the child involved with both parents to rectify any of the problems that the parents are experiencing themselves. And maybe it means that one parent might have a little bit more parenting time for a little while until the other parent gets things in order. But eventually, hopefully, everything will work out and both parents can enjoy all the joys of raising their child together.
Sam, do you think that Joe should compromise on anything?
I think there are a few different things here that Joe could consider compromising on. I think in the scenario, what sticks out to me is the different extracurricular activities that Joe's interested in. Of course, we want our children to participate in everything possible, but maybe he could talk to Sophie about that. These things are all going to cost money, but that's all going to require Sophie to come to the table and actually have a reasonable discussion. I do have concerns, just as Kim stated earlier, I have concerns about the alcoholism and the parental alienation. I mean, Sophie's choices right now are very concerning, and it looks like they're going to need to work together with an attorney and probably with the court system to come up with a really good plan for Max's safety and ability to be with both of his parents.
So thank you to both of you. I am also going to address this next question, because when we deal with alienation and when we deal with absconding with a child, that's very serious, and we have a lot of that, and unfortunately we see a lot of across state lines absconding, and we have to take very swift action because the laws are very clear, but it can be very detrimental to the other parent if it goes on for too long. So here in this situation, if Sophie is not responding to Joe, if Sophie is not responding to a lawyer or any type of service, a process of a motion or a complaint, then there should not be early on mediation or settlement. It really needs to be an aggressive tactic, because if Sophie feels that she can get away with absconding with her child, she will, and she'll leave the state, possibly if they cannot come to terms or some resolution early on. And trial, again, the last question, do you think Joe should go to trial? Now, trial is after the process continues for some months. In Michigan, in order to go to trial, you have to have a period of discovery, and it's truly litigation. There's subpoenas, there's interrogatories, sometimes depositions, sometimes experts have to get involved when there's custody issues, such as counselors or therapists, what's in the best interest of the child. So in alcoholism here. So there are many issues that go into that, and the majority of cases nowadays with family law issues and divorce and custody in particular are settled out of court. So if there is a discovery process and the court determines that mediation would be the best way to try to resolve this, then the judge will then order mediation where the two parties go with their lawyers with another person, usually an attorney, to try to settle the case. That attorney acts like a judge and would order what the judge typically would do. Now, if it can't settle at mediation, then of course it goes to trial. In this case, hopefully it doesn't get that far, but it seems if the two parties are extremely at odds, then there really is no other choice than to try to settle either at mediation, or then unfortunately, they would have to go to trial. So this is what I touched on just a couple slideshows ago, collaborative divorce. Now, many states are now coming up with this process where two parties agree early on to not argue in court over their issues, that they come together collaboratively and they meet with a neutral person before any paperwork is filed, and they come up with the agreement or the settlement of their divorce and custody, or just a divorce, or just a custody. It just depends on whether they were married or not, and whether they have children or not. There are many pros to this process in that usually it shortens the time that it would take to settle. There's less hostility, there is more communication between the parties, and sometimes it does help to maintain a better relationship, especially if there's children involved. Now, there are many, many cons to this though, however, and I say it only because we see this every day. When two people go try to collaborate and try to settle their differences with a neutral third party, usually one of the persons, the one that's driving it, right, driving the train, driving the bus, really has more of a stronger voice, and the other person usually feels more suppressed and doesn't feel like their side is really getting heard. And so it's not an equitable resolution of either the property, the money, or the child custody issues. So if there is an imbalance, that will usually come out in the collaborative process. There could potentially be a disagreement. Now, if at one point down the collaborative road, one of the parties talks to someone and they say, hey, this doesn't sound fair, and then they all of a sudden wake up and they're like, oh my gosh, I don't want to do this anymore, then everything has to be basically put aside, and then they have to start the process all over again with lawyers, going back to court or going to court for the first time, and everything kind of implodes. They also, even if the collaborative divorce process ends successfully, that neutral person helping them cannot represent either one of them. And in every state, you still have to file the complaint for divorce. You still have to go through the statutory waiting period of filing the divorce, getting either the answer or a default, and not answering, and then settling and filing the paperwork at the end. So either way, you still have to go to court. So even if you are getting along, you can still get along, file the paperwork, have a lawyer guide you with it, and make sure all the necessary paperwork is completed, all the T's are crossed, the I's are dotted. And truly, if you're getting along, you really don't need the collaborative divorce process. You can just go ahead and do it without that neutral third party. Because like I said, you still have to go to court, file the complaint, and file the judgment, and you still have to do the waiting period that every state requires in order to have that final order entered. So here is what we think you need in your toolbox to navigate success for your co-parenting journey. We think you need a parenting plan, which is flexible yet structured. And again, try to think of the things that you want. Try to get clear on how you see your life and your child's life moving in the next 5 to 10 years or longer, so that you can plan what is the best parenting plan, the parenting time for you and your child, because your child really will go through phases too, depending on the ages of them. Are they toddlers? Are they infants? Are they preteens, teens? Everyone has a different parenting time that is suitable for your particular needs, your family's needs. And you really want to try to face those head on, before you enter the final judgment. And try to de-escalate certain things, avoid blame. If there are issues that arise with your co-parent, whether it's during the separation or during the litigation process or even after the judgment's entered, try not to say, blame the other person. Use more I statements. I feel, I think, I think this is happening with our child. How can we best resolve this? Try not to be vindictive. Use much more professional, amicable communication skills, and keep everything in writing so that you can keep it documented. And if necessary, get that support you need with a therapist. Maybe ask your lawyer, what kind of parenting time coordinator can I use? Maybe a neutral mediator can be reserved in your final paperwork for anything that comes up down the road. And that will help prevent things from escalating too much. And a lot of times we put in our final paperwork, if there's a conflict, if this occurs, if there's any issue, and you can specify those issues, then we want to see Mr. So-and-so or Ms. So-and-so as a mediator to help resolve those issues. Or we'll agree to family counseling, or we'll go to the parenting time coordinator. Anything that will help de-escalate and really propel your family unit to move forward. Because even though your family is different now, you're going to have your own family with your child, and so is your co-parent, but you're all still connected. And again, parenting is a lifelong commitment to your child, and you always have to remember that. So take it from us, because we see this all the time. There could be failure, right? We can navigate your way to failure with severe miscommunication, non-compliance with the judgment or the terms of your agreement. And that leads to costly litigation, strained relationship, your children who are highly, just, in fear, anxious, they don't want to be with you, they don't want to be at any person's home, they get very upset. Or you can have success. A couple is able to create and stick to a cooperative parenting plan while settling their disagreements. And what is the difference? How can we navigate you towards success as opposed to failure? Well, the difference, what we find in our tremendous amount of years of experience, is really early intervention, continued guidance by a trusted individual or system. And that could either be a trusted friend, a confidant, your lawyer, a therapist, a priest, a rabbi, anyone that you feel is really there for you and your best interest, who's not afraid to tell you the way it is, who you will really take guidance from. And you want to make sure you're not getting defensive, you're not reacting. You want to look at yourself and really look at yourself from a radical eye, from just taking radical responsibility for where you are now versus where you want to be. Because if you continue doing what you did, you're never going to advance to becoming better. If you continue doing what you did, you're going to get the same results, whether it's with a relationship or without. Your life will always be stagnant. So we want to look toward inner growth, self-reflection, so that we can grow and improve from all of the lessons without self-blaming or blaming the other person. We really have to sort of erase the past and just move forward, but learn from it so that we don't continue making the same mistakes. Well, Ariana, our wonderful legal assistant in the back, is going to read this next case study for us.
Yes, for our next scenario, we have Samantha filed a custody and parenting time complaint against Rob after the relationship ended, fearing his anger and substance abuse could harm their two children, ages 7 and 9. Despite wanting Rob involved, she pleaded with him to seek counseling and rehab, but he denied having a problem and refused. Filing the complaint without an attorney, Samantha soon realized she needed legal help to navigate the process and hired representation. Rob remained aggressive throughout the case, denying his issues and opposing Samantha at every turn. Knowing Samantha lacked evidence to prove her position and still wanting to protect Rob's reputation, she agreed to mediation in lieu of trial. In mediation, Samantha agreed to equal parenting time contingent upon Rob using a co-parenting app, attending anger management, and his abstaining from substance use around the children. So how would you have handled Samantha's situation?
Well, Kimberly, would you like to respond?
Well, again, this concerns substance abuse, rehab issues. There are ways to get help for a parent who needs that kind of help. And they can still be a parent to their child. Samantha really does, though, need to have the evidence to prove these things. She can't just go to court and say, I think this is what's happening. And the judge is gonna say, well, where's your proof? And if she doesn't have anything, then Rob is gonna get the benefit of the doubt. If he's saying, I'm fine, nothing's going on. So you have to have the evidence, have to have the journal, have to have, all of that like we've been talking about. But again, if they end up going into a parenting time agreement of some sort, and maybe there's things in place like drug testing or alcohol testing before parenting time, if in fact it's found out that Rob really does have a problem. And anger management is a good thing too. A lot of courts order that when people with addictions also have a lot of times anger issues as well. So there are ways to get around all of these predicaments. It's not involving absconding with children or denying the other parent any parenting time. It's working out a schedule, whether it's with the help of a mediator, whether it's after a collaborative effort or at a trial. There's going to be a parenting time schedule issued. And if there are conditions that need to be placed on parenting time for whatever reason, then those things can be put in place to protect the children.
Thank you, Kim. Do we have another question coming up? So 2 months after mediation, Rob did complete anger management, just like Kim suggested, but Samantha remained concerned about his substance use during parenting time. The children's school reported tardiness and absences during Rob's time, and Samantha noticed disruptions in the children's sleep schedules. The children also mentioned Rob spending time with friends in the garage and acting unusually silly afterward. Though no harm had occurred yet, Samantha, familiar with Rob's patterns, grew increasingly worried and informed her attorney of this. Her attorney advised her to wait since the children weren't in immediate danger. Eventually, Rob's behavior escalated, with the children calling Samantha in tears, reporting that Rob was screaming, smashing objects, and hitting them. When Samantha arrived to pick them up, Rob blocked her entry and threatened to call the police. Kim, again, what do you think Samantha should do?
Well, Samantha might have the police come herself, or maybe even, you don't want to do this as a last resort, but maybe there needs to be an investigation by the state at Rob's house to find out what really is going on there. If Rob does not have a problem, then he should submit to a drug or alcohol test if the court so orders. And maybe that will prove one way or the other what's really going on. Does Rob have a problem or not? Maybe he's just dealing with something else and expressing it in this way, who knows? But yeah, Samantha, if she fears for the safety of herself or her children, she should call the authorities herself or have a formal investigation done to get to the bottom of it.
Samantha, do you have anything to add to that?
No, I absolutely agree with a lot of what Kim said. I think it's important to highlight here that in this second scenario, Samantha actually had a little bit more proof than she may have in the beginning. I mean, having those calls from her children, they're younger children, but they understand and they've been communicating with her. And the fact that Rob did submit to this anger management, and maybe it was working before, but shortly after these classes ended, Samantha started noticing issues, and she's got those attendance records for the children. And I agree with Kim, it may be necessary to call the police and have this documented so that if she does need to go to court, she has this information to show the judge to push for that evaluation.
So we as lawyers really can only do as much as the facts allow, and you are our case, right? So with your help, we can really put forward our best case, and we'll guide you along the way. We'll tell you what we need, but unfortunately, we cannot create the facts. And so we need you to help us help you. So, getting that documentation, getting the evidence, all of that is necessary, and you really have to be your strongest advocate for you and your children. Because in order for us to help you, we need to know what's really going on, and if, you know, like they both said, you need to call the police, and if you didn't, then we'll ask you why. And if you're truly insistent upon the drug testing and the alcohol testing, which obviously is necessary here, especially in a case like this, sometimes the court will make it reciprocal, meaning you will have to undergo those same tests that we are demanding of the other party. If there's a psychological evaluation that needs to be done in order to determine the best interest, you know, some of the best interest factors for the child, if that parent is suited and a fit parent, suitable and fit parent for that child, then you oftentimes will get ordered to undergo a psychological evaluation. So courts are reciprocal in those types of things, just like reciprocal restraining orders when it comes to assets or certain things with the children. It's very reciprocal. So what we are asking of the other person, you too have to do for yourself. So really that's what we say for this, now we're ending this last hypothetical. We hope it really helped you. We hope some of these questions and answers really guided you for your own particular scenario. And if you do have more pressing questions, you can always call us at Genesis Legal Group. You can email us. For those in attendance today, we'll give you definitely complimentary consultations. Please send an email to seminars@genesislegalgroup.com. We'll be sending PDFs of this presentation to all of our attendees. And we're going to be having these presentations every month moving forward on various topics of family law. So if there's anything else that you need, we're always here for you. But just for some final takeaways of this seminar, because our time is quickly wrapping up, we just want to ensure that you try to reduce the conflict, not only for yourself, but for your children. And your happiness and your contentment is really, truly what matters. Because when you're content, when you're happy, your children will be. There will be more harmonious relationships all around. Everyone will feel safe in their homes and secure. And that's really what we're trying to provide for you, is a safe environment to raise your children so that your children grow up to be happy and healthy adults. And the legal tools that we're providing for you and our pragmatic approaches to some of these tough questions are really there to guide you, but not to replace your innate ability to parent and your instincts to be that good parent, because your instincts are really the barometer. They're really the compass that you need. Just trust yourself, trust your instincts, and any type of situation will really be resolved in the best way possible. And whether those instincts tell you to do something yourself or to call a trusted friend or your lawyer or a counselor, use that. Use your compass wisely to chart that path that prioritizes your child and their well-being. So with that, unless there's other chats, do we have any other questions in our chat?
So we do not have any other questions at the moment, mostly just thank yous and well done, and excellent job for answering all of their questions. They're really appreciative.
Well, if you have any further questions, please email us. And please go back. Maybe if you want to look at our social media, please, we would be so happy if you wanted to engage with us on social media. And if you really found some value in our presentation today, if you could please get us, put on your Google review hat and give us a 5-star review. We would really, really be super grateful for that. We really strive to be here for you and to provide value for you. And it's our passion, every one of us here at Genesis Legal Group, it's our passion to help you live your best life. And if we've given you some value today, we would really appreciate that review so that we can help and other people can find us to help other people live their best lives as well. So thank you so much for being with us. We're grateful, and we hope you have a wonderful rest of January. And we are rooting for 2025 being the best year yet for each and every one of you. Thank you so much.
Bye.
Bye.